Good morning, ladies and gentlemen. Thank you for joining CDH for this webinar on force majeure in turbulent times. We do appreciate that so many of you found time during your day to be able to join the session. I'm Jack Ferris, a partner at Deco Hoffmey in our dispute resolution practice, focusing on energy, mining and natural resources, and also investment law issues on the continent. So today's webinar is an important discussion about FM, the importance thereof, and in particular with reference to what is happening currently from a global perspective, the geopolitical changes that is being experienced, headwinds that all companies and individuals globally are feeling as a consequence of what's happening in Europe with reference to the war in Ukraine and Russia, what's happening in China, still as a consequence of COVID restrictions and the zero policy on COVID, which has had significant impacts on supply chains and supplies for the global economy. And those things have had ripple effects on contractual obligations for various parties as a consequence of these geopolitical changes and headwinds being experienced. Now, today, we want to unpack those things with reference to legally speaking. So as parties that operate within the continent, in South Africa and various other jurisdictions on the continent, what are those things that you should be considering with reference to force majeure, risk mitigation, and also the various dispute resolution mechanisms that can be invoked as a consequence of force majeure or a purported force majeure. So to discuss these issues, I have an esteemed panel of colleagues from CDH, all female, to add to that, that are very skilled in dispute settlement and these type of contractual issues that typically flow from contractual constraints and issues that parties have raised. So with me on the panel is, I'm going to start with Tiffany Jechels. Tiffany is a director in our dispute resolution practice. She has experience in commercial litigation and arbitration proceedings, administrative and procurement law, access to information review applications, including general litigation proceedings. Her focus area is mainly commercial litigation, mining, and administrative law from both a regulatory and compliance perspective. Then next, we have Lucindy Rudy. She's a director also in our dispute resolution practice since 2005 and has vast experience in complex commercial litigation matters, business rescue, restructuring and insolvency, Companies Act litigation matters, and disputes, financial markets, market abuse litigation, and corporate investigation. Last but not least, we have Belinda Scribber, who is also director in our dispute resolution practice and ranked in best lawyers for 2020 in litigation. She is a member of our insolvency and business rescue unit. Her extensive experience includes litigation and arbitration, both local and international areas of insolvency and business rescue, corporate and commercial contractual disputes, Companies Act disputes, maritime, international trade. She has more recently trained and qualified as a mediator. We unfortunately had another panelist, one of our esteemed colleagues, Tabile Furman. She could not join us as a consequence of a family emergency. But we still have a very powerful team of female lawyers that will be able to unpack for you the complexity of force majeure and all the related issues as we will be doing during the session. Now, before I hand over to the first panel member, Tiffany, just some housekeeping rules in respect of today's session. So if you have any questions, so flowing from the discussion by any of the panel members, please feel free to post that on the chat box. I will then pose those questions to the panel members, either during their session or at the end when we have a full Q&A session. If we don't get to all the questions, what we will intend to do is post the session, we will respond to each of you directly to try and answer the questions that you have raised. and potentially maybe engage with you on those issues. So now to the panel and to the panel discussion. So the first speaker, as I mentioned, will be Tiffany Jechels. She will be setting the scene for us with reference to looking at a particular English law case, because English law, when we look at what happens, particularly on the continent and international commercial agreements and cross-border transactions, we typically find that English law will govern those contracts. And we will obviously also touch on South African law and the applicability on that, but we thought it's useful that we give you a case that is with reference to what's happening from a global perspective and the principles applied from an English law perspective, because that is also what most contracts you would find on the continent. So I'm going to first hand over to Tiffany to set the scene with reference to the factual synopsis on the English law case and some of the pertinent considerations in respect of force majeure. Tiffany, over to you.
Thank you, Jackal. Good morning, everyone. So for purposes of our discussion, like Jackal mentioned this morning, I will discuss the facts of the classic maritime case, which is an English law case, and I'll discuss the various legal principles in respect of the defense of force majeure as raised by the defendant in this matter. So briefly, the facts of this matter is that the parties concluded a long-term contract of affreightment for the shipment of iron ore pellets from Brazil to Malaysia, which contract was then governed by the English law. During November 2015, there was a dam burst which resulted in a halt, the production of the iron ore being halted, which all the means for the defendant then to source the iron ore was destroyed, and it prevented them from any possible performance in terms of their contract of affreightment. Consequently, it rendered the shipping of the iron ore pellets from Brazil to Mozambique impossible for a particular period of time. The contract contained an exceptions clause, but it was worded very similar to what we know as the force majeure clause. The clause provided for an exclusion of liability for loss or damage resulting from a series of events which was specified in the contract, which included an event which would also anticipate the dam burst directly affecting the performance of either one of the parties. The defendant in the matter then raised the impossibility of performance in reliance of this exceptions provision in the contract, and the dispute then concerned the shipment of 5 out of 7 shipments. Prior to the incident, the defendant was, however, unable to perform 1 or 2 of the shipments because of financial difficulty. The High Court then held that the defendant was unable to rely on the exceptions clause, even though objectively viewed, the performance under the contract was wholly impossible because of the dam burst. How the High Court came to that conclusion was that they applied the but-for test. But the test was applied that but for the dam burst, would the defendant have performed? The High Court looked at the intention of the defendant. Did the defendant have the intention to perform prior to the dam burst? And the courts found that the defendant didn't have the intention to perform, and therefore the defendant was precluded from relying on the exceptions clause. The High Court then took it one step further and said, well, even if the defendant didn't have the intention to perform, when I assess the plaintiff's damages being claimed, I have to factually look at whether or not the defendant would have been able to perform. And the High Court found that because factually the dam burst did occur, the plaintiff wasn't entitled to the substantial damages that they claimed, and the High Court only granted them nominal damages for the defendant's non-performance. The claimant then took the matter on appeal in order to challenge the court's finding on the damages. Essentially, what the defendant said was, if the court finds that but for the dam burst, the defendant cannot rely on the exceptions clause, then the court cannot apply this principle in order to reduce the claimant's damages. So in the appeal court, the the appeal court upheld the submissions made by the claimant, being that the defendant never had the intention to perform. Therefore, they shouldn't be able to rely on the exceptions provision in order to reduce the claimant's damages. And the appeal court then awarded the claimant the full damages based on the exceptions provision. What's important in this case is, ordinarily in South African law, we will say, but for the FM event, were you able to perform, yes or no? What the court did in this matter was they looked to the defendant's intention, and the court held, well, you never had the intention to perform, therefore you're unable to rely on this FM event in order to reduce your liability. How the clause was worded in this provision is important to facilitate also the discussions by my colleague Lucinda and Belinda. The court in the High Court said, well, this clause was called an exceptions provision and it wasn't called an FM or force majeure clause. Therefore, the general principles of the FM provisions shouldn't apply. How the provision was worded was, neither the vessel, nor the master or the owners, nor the charters, or the shippers or receivers shall be responsible for loss or damage to or failure to supply or discharge the load of the cargo resulting from. And it listed a series of events, one of which is an act of God, which we know to be similar to the FM events, accidents at the mine, production at the facility, or any other event beyond the shippers or the charters' control, provided that such events directly affected the performance of the party. So the wording of this provision became very important as to how the court applied the but-for principle. And because of the wording of this provision, the court looked to the intention of the parties as opposed to the general FM provisions. I think that's a summary of the facts for now, Jacko.
Thank you, Tiffany. Then just in terms of, so from a practical application perspective in respect of contracts that we find, particularly cross-border contracts, and we have supply issues, either there's issues in respect of crude oil that are not supplied as a consequence of events happening in Ukraine or events happening in the Middle East. How would you apply that in a context of a supply event of that nature with reference to the principal segment in the maritime case, if English law was also applicable? So you have a shipment coming into the port of Durban, and there should be a shipment coming into the port of Durban as a consequence of whatever happened in Ukraine or wherever the geopolitical issue is. There's a 10 or 15-day delay. What test will be applied? Would you still apply the but-for test? Is it impossible? Or what type of assistance would you give to a client in that type of scenario, or advice?
Is where the performance is limited for a particular period of time.
As a consequence of the supply delay.
Yeah. So, Jackal, just importantly, for purposes of this case, it appeared that what the court was trying to do was obviously eliminate instances in which defendants opportunistically try to rely on FM events. But the correct way in which to apply the but-for test, especially from a South African perspective, is but for the FM event, would you be able to supply, yes or no? We don't look as to the intention of the parties. So from my perspective, if you are unable to perform based on that FM event, then you would be protected. So the courts in South Africa won't go beyond the but-for test insofar as your intention is concerned, if that makes sense. So, but for the event, are you able to apply or perform, yes or no?
Thank you, Tiffany. I think you've set the scene with that particular case on maritime. And I think Belinda can maybe add to that in respect of just unpacking the specific principles from a FM perspective again, from a contractual perspective, how that's viewed and seen, and also the dispute settlement mechanisms that we typically get, and how do we, or how parties should then invoke that or deal with that. Belinda, over to you.
Thanks, Jackal. Thanks, Tiffany. Yeah, so I just wanted to touch a little bit on whether force majeure is, on a continental perspective and a global perspective, quite a common clause to have. And it's becoming increasingly common. In South Africa, it is something that's new. It's something that's we've received from continental Europe. We generally used to have, and still do actually, a term called vis major, which is a Latin term and roughly translates to an act of God. But what force majeure does is it is a specific clause now that is being incorporated into contracts in order to generally limit liability of a party for an event that is beyond their control. So you'd have to be very, very careful how you word that clause to make sure that the event in terms of the commercial transaction is something that is realistic. It's not something that's necessarily foreseeable, but it's just something that could possibly happen and should possibly be covered by the contract. So be very careful when you're wording your force majeure clauses. And then when you are applying whether it is a force majeure, look at your contract very carefully, see if it is an exclusion that you can rely on or that the other party is trying to rely on, and whether it's actually in. Don't just assume there's a force majeure clause, therefore it can be relied on. I think look very, very carefully at the force majeure clause. Also, the other reason to look carefully at the force majeure clauses, and a lot of the clauses, although they have exclusions of liability, some of them have clauses which have exclusions of defenses against liability. And one of the main examples I can think of that is where you have got a force majeure clause, but it doesn't apply, for example, to terrorist attacks. So then, although there's a force majeure, it's beyond your control, the contract specifically excludes that as an exclusion of liability for a party to rely on. Then the question is assuming there's no force majeure clause. So assuming your contract doesn't have a force majeure clause, but something comes along that actually makes it impossible for parties to actually act, and it was an event that was out of their control, they didn't cause, and it's making it impossible for them to fulfill their contractual obligations. In South Africa and a lot of the continental jurisdictions and across the globe is a principle called supervening impossibility. So something happens, it's not covered by your contract, but it makes it impossible for you to perform in your contract. Now, in South African law, if a court finds that there is a supervening impossibility, then it will allow for the party that cannot contract to either get out of the contract, or it will suspend that party's obligations for a specific length of time. So on the case study that Tiffany has spelled out quite nicely for us, it's probably the courts in South Africa, assuming that we applied the but-for test strictly as Tiffany has relayed to you, the courts were probably in all circumstances on a supervening impossibility, assuming there was no clause. They'd probably find that supervening impossibility would terminate the contract, because it's an indefinite period of time if and when the mine would be up and running again to deliver the ore. With the force majeure clause, again, the courts might say, okay, this contract needs to be terminated. An event where the courts might not terminate the contract, but just suspend the working of a contract, either through the working of a force majeure clause or by applying a supervening impossibility, is, for example, take COVID-19. There were certain contracts that couldn't be performed as a result of lockdown, whether it was hard or the softer lockdowns. And as a result of that, for that period of time, courts have found in a lot of case law that parties that were unable to perform because of a supervening impossibility, their obligations are suspended. So the contract is not terminated, it's just their obligations are suspended for the period of time that they could not perform for. Non-performance, or the inability to perform, is not a commercial inability to perform. It's either a factual or a legal inability to perform. So just because we're coming out of hard lockdown, there's no clientele in order to come to a restaurant because people are still too scared. That period when you could reopen because hard lockdown restrictions have lifted, that period beyond will not be seen as a supervening impossibility because it's an objective test. So can you possibly open your doors and serve? No, because of the law. Okay, you can't perform. Can you open it? And you can, but you can't, you don't want to because it's not commercially viable. That's not seen as a good enough excuse for the courts to implement a supervening impossibility. So in summary, either your contract covers force majeure and it covers certain instances that you can rely on, or if it doesn't, parties can look to see whether the jurisdiction that their contract is applicable to has the principle of supervening impossibility and whether or not there is an actual impossibility, and they can rely on that. To ask the question for both, the impossibility must be created. It must be created by a direct and immediate cause of the event that you're going to be relying on. So it can't just be there was a dam burst in the Eastern Cape and it contaminated the water, therefore the Western Cape couldn't provide water because there was a possible. There's got to be a direct and actual cause and effect of the event that you're going to be relying on. And then the next thing I just wanted to cover is you've got to be very careful about when you're reading your, as I said before, when you're reading your force majeure clause against your breach clauses. So an example now is if the shipper in the case study that we had before, if the shipper, for example, in South Africa had already placed the charter party in breach before the force majeure event occurred, and the consequences of that breach had already occurred, for example, there was a termination of the contract, the force majeure would never have come into question because the termination event would have already occurred before the dam burst. So you look very, very carefully at your breach clauses when you trigger them, how quickly you trigger them, because that has consequences unto itself. If, for example, you had the breach clause and you terminated, or you had the breach clause and you had specific performance, then again the force majeure would come into play because now they've been forced to perform, but they can't perform. They really can't perform because the dam has burst. So you must look very carefully at the force majeure clauses read with your breach clauses as contracting parties. And then Jack will also touched on the fact that I'll go into the various dispute resolution mechanisms that you have open to you. Obviously, the first one is formal litigation through the courts. And that, again, you'll have to look at your contract, see what your contract says about the jurisdiction of your litigation. So where is the litigation going to take place? Again, as Jack said earlier, a lot of the continental contracts have jurisdiction in London. A lot of the contracts also have the law that is to be applied as English law. Parties do that. When parties do this deliberately, it's generally because there are parties that are contracting from different jurisdictions on the continent, and they want a neutral law and seat in order to settle their dispute. So they don't want the law of either of their country to apply. I think continental Europe is going to continental Africa is going to start thinking very carefully about finding local jurisdictions in order to settle their disputes, so local neutral jurisdictions, because it's becoming increasingly expensive and untenable to try and contract or to try and settle dispute in London using London mechanisms, and parties have to travel there, they have to spend time there, and the costs of having to litigate in London or even arbitrate is becoming increasingly higher. The advantage about arbitration clauses, which is the other alternative to litigation, the advantage about that is that you can actually start making bespoke mechanisms. So although parties want to use London as their base of law because perhaps both parties are familiar with English law, they could, for example, just say, okay, we'll have English law, but we'll have the seat in South Africa. Let's assume it's a dispute between a Botswanan-based company and a Namibian-based company. You can have your seat in South Africa and still apply apply English law. So you can start working and playing around a little bit with arbitration. The main advantage of arbitration is you can actually choose your arbiter. You can choose the person that is going to be settling your dispute. And the advantage of that is that person is generally chosen on the basis of their expertise. So they're familiar with the facts of the case or the industry that you're working in, and therefore it's much easier for them to get to grips with the issues that are in question and try and find a solution to that is it's applicable to law, but but they're au fait with the industry itself, which makes it a lot easier for them to get to a grasp on the specific law at hand around that specific industry. Then the last mechanism that is generally available, and it's becoming increasingly used, is mediation. A lot of people avoided mediation for a long time because they saw it as a very soft, untenable solution to a complex commercial contract. And ironically, the reason it's becoming more popular is because contracts that are being negotiated now are very complicated. They require a lengthy amount of negotiation, and the contracting parties actually, there is a very specific reason why those parties are entering into a contract together. So even though there is a dispute that has arisen, parties are increasingly wanting to find solutions where it's not going to result in an absolute fallout between the parties. So they're still going to be able to have a contractual or a commercial relationship with one another once the dispute has been settled. So what parties are increasingly doing is going to mediation. And mediation is a mechanism whereby the facilitator doesn't make a decision for the parties. What the facilitator does is he tries and helps the parties negotiate an orthogonal solution to a specific problem. So an example for now, assuming that there was an alternative supplier that could have provided iron ore and that the charterer was going to ship the iron ore, it could have possibly been negotiated that the charterer would be given a little bit of time to try and find an alternative. It could be that the charterer was also shipping other commodities from the area and possibly negotiating a way to, instead of shipping the iron ore, ship the other commodity that charterer is shipping. So trying to find a commercial solution to a problem instead of immediately entering into an adverse litigation or arbitral arena. And I think the other advantage about mediation is there's actually nothing to lose. If the parties don't come to any sort of resolution through the mediation process, which should be quite effective and quick, it shouldn't take more than 2 to 3 days. If they're unable to find a solution during that process, then they can still go to arbitration and mediation, and sometimes, litigation, and sometimes the mediations actually had the effect of it's limited what the issues are between the parties. So it makes the litigation and the arbitration much shorter and much easier to run because the issues are defined between the parties. So what you are finding more and more regularly now is within contracts, there is a mediation mechanism, and then there's an arbitration, or if not an arbitration, then a litigation mechanism to go directly to the dispute through one of the more formal modes of dispute resolution. It is advisable, if you want to use arbitration and mediation, to make sure that those mechanisms are included in your initial contract. If they're not, however, it doesn't mean that they're not available to you. It just means that you have to negotiate with the other side to make them available to you. And if you're already in an adverse relationship, it's unlikely that you're going to find an agreement on how to settle your dispute if it's not through the court process. So we do advise that you do think about your alternative dispute resolution mechanisms and whether or not they're applicable and could be used in your contracts. The only other disadvantage I would say about litigation is just that you are beholden to the court processes, whereas with arbitration and mediation, you're not beholden to court processes per se. The parties can define the rules. There are a lot of international mechanisms that are open now, which actually expedite the process for arbitration and mediation. So it can take a lot quicker to get through the process than if you go through the formal court procedures. So I think along with looking at your force majeure clauses, also make sure that you look very, very carefully at your breach clauses and your alternative dispute resolution clauses.
Thank you, Belinda, for that fantastic summary on FM provisions, and particularly what you need to look out for when you deal with a FM event. And in particular, the most important part of it is looking at your contract and looking at the provisions and seeing what does it actually entail for you to be able to rely on the FM event in a particular scenario. So Belinda, I think there's a few questions, but maybe before we get to the questions, we can maybe go over to Lucinda and we can have a few interactive discussions on some of these questions. There's a few that has come through, and then we can deal with it. So Lucinda,
sure.
Thanks, Belinda. In respect of just looking at what both Tiffany and Belinda has spoken about in respect of the case and the particular scenario, and then also what Belinda has set out in terms of FM events, what to look for and what not to do, and then the dispute settlement mechanisms. And from your perspective, risk mitigation that clients need to take into account, whether they are the party that is receiving the notice or the party that will ultimately issue the notice, what should be done, and what is your view on that?
Thanks, Jack. Well, morning, everybody. I think the question by now on everybody's mind is, okay, so on a practical level, how do we mitigate against these risks that has been discussed this morning? So, you know, in a perfect world, all of these mitigation steps and processes must actually start at the time when you are negotiating your agreement and when the agreement is being negotiated. And it's very important right at the early stage to be able to identify the possible risks and also to cater for that in the agreement. Now, I think firstly and most importantly, and this is outside of any contractual negotiations and not really within the scope of today's webinar, it is very important to make sure that your business has sufficient insurance cover. Whether in the firm of business interruption insurance, we've seen so many cases that was dealt with by our courts during the pandemic, in one or other form, just to cater for and indemnify your business against any claims, damages or losses that may be suffered as a result of force majeure or force majeure event. So on the basis that you make sure that you have your insurance in place. Secondly, as I said, one must be aware of what clauses needs to be negotiated while you are negotiating your agreement in order to make sure that you have the best protection, contractual protection out there. Now, I'm not going to go into too much detail because obviously, first and foremost, as Tiffany and Belinda has said, your force majeure clause. It is important to know your industry, to know your supply agreement, and to try and identify circumstances which may contractually be classified and included as force majeure event to ensure that if any of these circumstances happen, that it is clearly dealt with in your force majeure clause. This would potentially avoid future disputes as to whether certain events and or circumstances fell within your force majeure and afforded you the protection in terms of the agreement. A second issue, if you can negotiate it, is to make sure that you work into your agreement indemnification clauses. And I mentioned this because your business may find itself in a position where, on the one hand, it is a purchaser, where it sources equipment, raw material, for instance, from a foreign company. But at the same time, in the supply chain, you are also a seller and a supplier to end users. So therefore, if possible, it's important to try and negotiate that your initial beginning foreign seller provides you with certain indemnifications if for any reason the seller possibly endures a force majeure event which is not covered by your agreement with your end user, that what you have is that your supplier then indemnifies you for any claims, losses, damages which your business may suffer as a result of claims instituted by your end users due to your delay not being able to supply. Comes a little bit back to what Belinda spoke about. Your indemnification clauses must be distinguished from your exclusion of liability or limitation of liability clauses. It's also important to try and negotiate those clauses when you enter into the agreement. The purpose of these clauses, firstly, is to limit the nature of the damages that can be recovered from your business in the event that there is a force majeure event which may not be covered contractually, and again, talking towards your relationship maybe with your end users. And you would have seen a lot of these clauses where it says that no party would be able to recover any indirect, consequential type of damages or loss of profit, loss of income damages type of damages claim. So it's important, if you can, negotiate those type of limitation of liabilities or exclusion of liabilities clauses. So not only limiting the nature of your damages, but you can also try and negotiate to limit the quantum of your damages, where you can either agree to a maximum limit. For instance, whenever a damages claim is instituted against your business, it would not be more than a specific amount. Or we have also seen in commercial agreements where damages is, for instance, limited to all payments made by or to your business within the preceding 12 months. Where this becomes particularly important is to come back to Belinda's point on cross-border commercial agreements where different jurisdictions apply. We know that in different jurisdictions, different principles apply when you calculate and award damages. For instance, we know in the US, damages are awarded on a punitive scale. And one can get yourself into a lot of trouble if you, during negotiation, agree, for instance, that US law will apply to governing your contractual relationship, or that you will litigate in US courts. You can find yourself in trouble. So it's important when you talk about limitation of liability clauses or even exclusion of liability clauses, that these are the type of consequences and implications you take into account. Belinda has spoken a lot about alternative dispute resolution clauses and also governing law. I'm not going to go into too much detail. Again, very important when you negotiate to apply your mind when choosing the governing law that will apply. Remember, the governing law is the substantial law that either a court or an arbitration panel will take or will apply when determining the disputes, irrespective of where the arbitration is taking place. The seat of the arbitration can be Singapore, but English law can still apply. So when negotiating, it's very important that you seek appropriate legal advice to make sure that you understand the important consequences of the choice of law or governing law that you agree upon. Going back to the US example, where if you agree to US law applying, you are opening yourself up potentially to huge damages claims if it comes to that. Spoken about the seat of the arbitration. One finds that when contractual parties get into disputes, there is this almost unreasonable fear that if an arbitration takes place in the country of one of the parties, there's going to be some form of bias. And that is why parties choose a completely independent, neutral venue. But again, costs, convenience, that's issues that must be taken into account when negotiating your agreement. You're not always lucky enough to be in a position to negotiate these terms beforehand. So your business might find yourself in a situation where an agreement has already been concluded and then a force majeure event occurs. The key then is to react as quickly as possible to the situation. You need to carefully study your contract, and your force majeure clause should and would probably have certain formalities that needs to be applied to. For instance, you need to make sure that the situation meets all the conditions of the force majeure event. You need to notify the other contractual party of the force majeure event and ensure that you comply with all the other formal requirements as set out in the agreement in order for you to rely ultimately as a defense on force majeure. Frequently, and we've seen it a lot, by failing to notify another contract party of the happening of a force majeure event, you run the risk of losing that contractual right to rely on any circumstances that could in due course be considered by a court or arbitration panel. And also a very important step is, if a force majeure event occurs, is just to identify and maintain evidence in regard to the force majeure event, as well as evidence of your compliance with all formal requirements in order to invoke the protection of those clauses. Begin the paper trail, get your notices, get your evidence together to eventually be able to prove that the event that which occurred or did occur fell within the ambit of your force majeure. So ultimately, Jack, while risks inherent to a particular relationship can be managed through proactive assessment, careful contracting that addresses the business and the legal issues unique to your contractual relationship, I think if I can briefly sum up, critical considerations would include, as we said, careful assessment of your contractual relationship, its risks, its vulnerabilities, thoughtful preparation for careful negotiation of agreements in light of your business needs, again, taking into account risks and vulnerabilities, precise drafting of your agreements, dealing with the risk identifier, and then make sure that you have a specific and effective dispute resolution mechanism. I think those are some high-level thoughts just on the mitigation process.
Thank you, Lucinda. I think you've summarized it quite succinctly in respect of what you should consider, because those are the most pertinent issues that any party must consider pre-contractual negotiation, and also when you already have the contract, as you put it, the mechanisms that you should, or the tick boxes that you should go through in order to mitigate your risk, act quickly, act swiftly, understand your contract, and also engage the other party as quick as possible in respect of the various dispute settlement mechanisms to avoid a potential full-scale arbitration or litigation, as Belinda has also put it. So mediation becomes an important. So there's been quite a few questions that has been posted by our esteemed audience, and I think we can maybe just deal with one of them, a few of them, but one of them that I think we're all experiencing is the load shedding, and where the load shedding, depending, I would again think, depending on the nature of your business and enterprise, whether that does constitute force majeure, an act of God, or is it merely an event and we must live with it? What is your view? Maybe starting with Belinda and then Tiffany.
Yeah, so I think one of our audience members summarized it very, very well. I think at the beginning of load shedding, we could possibly have argued supervening impossibility. If it's not covered in your contract, that's the only other mechanism you can use, is to argue a supervening impossibility. But I think it's a bit late in the day to start arguing that. I think we need to, plans need to be made now. It is foreseeable. We know it's happening. We've been warned that it's going to happen. So I think in the beginning, yes. Now, if you want something specific covered in relation to load shedding and its consequences, you'll have to include it in your agreement.
Tiffany, do you have anything to add?
No, I agree with Belinda. I think at this stage we've got the schedules going. You need to make provision for load shedding. So there's generators, there's the inverters. We all have invested in these things now. So I think to the extent that we can foresee the load shedding, which we can to a large extent. I know sometimes the stages change, so you don't know if you're going to have load shedding for 2 to 4 hours, but the fact that load shedding is here, you know about it, you need to make provision for that, unless Belinda says you explicitly provide for that in your contract. So I agree with Belinda's.
Yeah, it's all about, in the current set of facts, it's foreseeability. We've known about, or know about it, have known about it for many, many years. So if you haven't gotten a generator or solar power by now, then you, or extra lights in the evening, then you will unfortunately have to suffer the consequences. And it's an unfortunate reality of life and business in South Africa now, where businesses need to invest in self-generation. The next question is a question by Sibusiso. If you are importing machines and the company you are buying from inserts a clause, so not an FM clause, in the agreement that results in unascertaining a price lead time, how can that be dealt with? So just, I'm not sure if you guys understand the question, but it seems, so it's not the FM clause, you bought products, the price and the lead time is not clear. How will you then deal with it? So there's then an issue with the essentialia, I would think, of the contract. But what is your view, Lucindy, if we can dissect that question?
Yeah, so I think this falls a little bit out of the realm of force majeure. I think one of the depending on the nature of your contract, as you say, Jack, while every contract has an essentialia, a number of points that needs to be agreed to, and price, especially in a supply or in a sale and purchase agreement, is one of them. If that has not been agreed to, and again, it depends on the business and what your business ultimately can endure. As a purchaser of the goods, where there is no agreement on price and no agreement on lead time, could be seen as a void agreement due to vagueness, because the parties just do not know what their rights and obligations are. And then we also have in our law situations where parties may in the agreement say that the parties will endeavor to agree on the price and lead time. That is what's classically known as an agreement to agree, and that is unenforceable in our law. So it's important when you get something like that and you see a draft agreement coming through where you have certain of those type of clauses, to go back and say, this is an unenforceable clause. What we need to build in is in the event of the parties not being able to agree, what will we do? And then there's usually a third party entity that you go to determine the price and the lead time. But I think it's highly risky to sign an agreement where there's no price and lead time defined, because it can just lead from a practical perspective to plan your business, run your cash flow. That would be extremely risky. And also the uncertainty about what are the parties, when can you phone up your supplier and say, listen, delivery is late. So we must, in such circumstances, we will in all likelihood advise client not to sign such an agreement.
Thank you, Lucindy. Belinda, anything to add?
No, I agree completely with Lucinda.
Yeah, it's a precise analysis of the issue. Then another question from Bishop Pillay: how does a warranty of services clause affect the FM clause? And I can maybe hand this to Tiffany and then Belinda. You're on mute, Tiffany.
Oh, sorry about that. My view is simple. So if ordinarily I will give you a warranty that I can perform certain things at a particular time. However, remember, the FM is something that I cannot foresee. So I don't think that my warranty towards the counterpart will preclude me from relying on an FM, despite me giving the warranty. So I think the party will still be able to rely on an FM, again, provided that they can demonstrate that but for the FM, they couldn't perform, or they would have been able to perform. So I think, yes, we like to give warranties, but I don't think that precludes us from relying on FMs.
Thank you, Tiffany. Anyone else want to add? Tiffany has summarized it well.
I think Tiffany has summarized it well. And I think if you've got an FM clause in there, you've got it in there for a reason. And so if you've got a warranty and an FM clause, then it is, I think the parties have anticipated that there might be something that would interfere with the warranty, which is why you would have an, I mean, specifically, especially if the FM clause and the warranty clause speak to each other, then I think you can say that the parties anticipated that there could possibly be, for want of a better word, a breach of a warranty because of an FM, and the FM clause is designed to cover that.
Thank you, Belinda. Then another question by Manette Nokia. If a party is in mora at the time of the supervening impossibility, they carry the risk, so won't be freed by impossibility. That's a statement, but maybe Lucinda can also deal with that.
Yeah, I think it comes back to the but-for test. I think that question fits in perfectly with the case study. If a party is already in mora, I think impossibility, unless the party can show that the impossibility of performance caused him to be in mora and that was the sole reason for it. But if you're already in mora, it's going to be a factual question at the end of the day. Because, I mean, obviously, just from a timing perspective, you will not perform, you'll get a letter of demand, and then you will raise impossibility, supervening impossibility as a defense as to why you were in mora. But you'll have to look at the facts, have to look at the timeline, and have to meet the but-for test. Yeah.
Thank you, Lucinda. Then a question again, I think from, I skipped some questions. No, from Melissa van der Merwe, DHL Supply. Supervening impossibility and FM clause can, in certain instances, work alongside each other, correct? If the FM clause does not make it clear that the parties are contracting out of the common law position, and the FM clause does not cover all the scenarios, I apologize if this has been discussed, but maybe Belinda, you can maybe touch on the point of FM clauses, supervening impossibility, because you've dealt with that to some extent, and then the issue of excluding common law and contract.
Okay, yeah, I think it's advisable, and you'll see it in a lot of FM clauses that they will, and also this clause here, I think, has it. It lists a whole specific category of events, and then it says, or other causes beyond the owner's control, or other causes beyond X's control. So there's generally, and we advise you do this, there's generally a catch-all clause in there. So even though it's not listed specifically, if it's related, the courts will look at it and say, it's not listed, but it's similar, or it's along the same lines, if you've got that clause in there. So always have a catch-all clause in there. And we say that whenever you're listing something, have a catch-all clause in there, because you can't possibly think of every single scenario that could possibly go wrong. So yeah, I think you would have it in there. Whether or not a court would see a supervening impossibility beyond the force majeure clause, I'm not 100% sure. I haven't seen any case law on that basis, but I think a court would probably consider it unless there's an exclusion clause in the force majeure clause. So if there's like I said before, if it doesn't cover X, Y, Z, then if X, Y, and Z is the supervening impossibility, it's been excluded as a defense to your failure to perform. So then the supervening impossibility wouldn't come in because you've excluded it specifically in your contract.
Thank you, Belinda. I think that's another important tip, to say that you must make sure that don't have a limited list of what constitute FM events. It should be open-ended list, because there's a number of events, as we've seen with pandemics in the past. You didn't have a specific, in the clause it's reference a pandemic such as COVID, but now most new FM clauses do include such events. So rather make it open-ended to make sure that you can rely on those clauses when that particular event happens that makes your performance impossible. Thank you, Belinda. And then another question. It's load shedding again. I think we've answered that question. From Minty again, there's a question. Could you compare South Africa's concept of supervening impossibility with English European? From what I understand, the SA test is a lot stricter. Example, doesn't consider frustration of purpose. Tiffany, maybe Lucinda, you can.
Yeah, I think maybe Tiffany is better placed to answer this one, because the purpose principle that's in the last part of the question is not something that certainly I've come across in South African case law. Tiffany, I don't know if you have more insight on that question.
Sorry, let me unmute myself. So just to clarify, so I'm just in the chat box. So the question is, could we compare the South African concept of supervening impossibility with the English or European? And from what I understand, the South African test is a lot stricter. Does it consider the frustration of the purpose? In the case that we discussed, actually, the court made a distinction between contractual frustration and obviously the FM. From the court's perspective, the contractual frustration dealt with the future performance of the contract. In this case, and I think this will give clarity to the question, because of the way the provision was drafted in the contract, the court went outside of the general scope, which is in South Africa, like I said, the but-for test is, would you have been able to perform if not, if this event didn't happen, yes or no, and we don't go beyond that inquiry. In this case, the court went beyond that to say, well, but for this event, did you have the intention to perform? And because the defendant did not have the intention to perform, they were precluded from relying on the exceptions clause, which is similar to the FM provision. I don't know if that answers the question, but I wouldn't say the South African test is stricter, because the South African test is basically a yes or no. Would you be able to perform but for the event, yes or no? Whereas in the case that we discussed, the court looked at the intention of the defendant. Does that answer the question, Jacqueline?
I think you have Tiffany. So with reference to the English law approach, and if you want the South African law approach, which is actually the English law approach is more stricter than the South, not the other way around, than the South African approach.
Sorry, Jacqueline, maybe just on that point, when you look at impossibility of performance from the South African perspective, one must just keep in mind it's always an objective test. It's not a subjective test. So, I mean, if a contracting party who wants to rely on supervening impossibility of performance, if any of the facts indicate that subjectively that party did or did not do anything that should have been done, then of course the court will not come to its assistance.
Yeah, that's good. Thank you, Listen. We still have a few other questions. I see there's hands up. Also, if you don't mind, I think I see Evans has a hand up. If you don't mind posting your question on the chat box, and we'll definitely answer that for you. We're just trying to make sure we manage the discussion. Thank you, Evan. Then the other question that we have is, I just want to go back to the quick question in relation to whether Belinda can answer this in relation to arbitration institutions in Southern Africa, whether AFSA is the only one or is there any other institutions that parties can consider from a Southern African perspective that are reputable.
Sure, sorry. I think I'm breaking up a little bit. So if I break up, I'm actually going to refer it to Jackal, because he is also very well placed to confirm this. But AFSA is not the only forum. There are a few forums. There's forums in various jurisdictions. Parties can have an ad hoc, so you can decide how you're going to structure your arbitration. So a lot of people go through AFSA because it's got a very formal structure, but there are a lot of different institutions that do, and you can find that we can provide you with a list if you want, or you can do what we call it, as I said, an ad hoc mediation, where you decide you're using AFSA rules, but you're not going to use the AFSA procedure. You're going to rather appoint the arbitrator on your own, off your own bat, and the parties then choose their decide amongst themselves which arbitrator they're going to use, how they're going to use that arbitrator, and what expert he is. So it's very much it's dependent on what the parties want and what they need. Are there more than one institution? Yes. Do you have to use an institution? No. I hope that answers the question.
Yeah. Thank you, Belinda. So as Belinda said, so it depends on obviously the parties and also how you structure your arbitration clause. So if you already have a contract, there's typically already arbitration clause in there, and it will select the institution, and it will typically, if it's a South African contract, or even in SADC, you would get AFSA as the preferred body. But there is other institutions that you can also look at, which we work with quite closely. It's MIAC, which is the Mauritian Institute for Arbitration, based obviously in Port Louis. That's the only other reputable institution that you would find. Then if the ad hoc means what Belinda says, if you don't want your arbitration to be administered by an institution like AFSA, you can agree to the Universal rules, you can agree to the Association for Arbitrators. They also have rules, and then the parties essentially run the arbitration, they appoint the arbitrator and carry on. And there's various other institutions on the continent that you can also consider. You don't necessarily just have to consider a Southern African institution like AFSA. There is institutions in Kenya, the Kenyan Arbitration Center in Kigali. Both of them are reputable, and in Nigeria and in Egypt. So there's quite a few. And then there's also another institution in South Africa, which is part of AFSA, which is the China Africa Arbitration Center, which is also for those cross-border disputes that you would want to consider. So just to add on to what Belinda said. Other question, how does one adequately mitigate against FM in a intercomaterms agreement? So either Belinda or Cindy.
I think when you have an agreement, if I have the question correct, is if you have an agreement that incorporates certain Incoterms has the purpose and the duty of assigning risk. So the one way in which to mitigate against that is to work in exclusions in your agreement, is to say, although Incoterms, whatever will apply to the supply agreement, we specifically by agreement exclude X, Y, and Z. And again, as I think it was either Belinda or Tiffany who answered this question, if there is an FM event, that will always override whatever other Incoterms risk apportionment there is, insofar as you can place the event within the force majeure clause. So I think that should answer the question, Belinda, unless you have anything else to add.
No, I think you've covered it more than adequately, Lucinda. I think what you must also bear in mind is there is an exhaustive list of Incoterms. I think we tend to focus on specific ones that are more commonly known, but there is an exhaustive list that in itself has exclusions and inclusions. So always make sure you look very carefully at the Incoterms and see if you even need a force majeure if you choose the right Incoterm. So yeah, just maybe to make sure when you're drafting the contracts, you just ask your attorney, the terms are there, and just your attorney will let you know whether there's a specific Incoterm that covers precisely what you need. If it doesn't, then as Lucinda says, then just add an extra force majeure clause or exclusion in your contract.
Okay, thank you, Belinda and Lucinda. Then the next question, we have quite a few questions. So there's a question, I think, Belinda, you dealt with it. So on tobacco, asked if you can maybe in brief, concisely, just summarize again the difference between the relationship, interrelationship between FM and breach clauses.
So your FM clause is very similar to what we'll do is we'll ask our marketing team to circulate the case from which we took the case study. So your FM clauses are very, very precise as to what qualifies as an exception or not as an exception. And so what you need to do is look very carefully at your FM clause to see if the event falls within that. It might be that a party is skirting on the edge of it, and another party will say it doesn't fall within the FM, and then they will start looking at the breach clauses. So when you are considering an FM clause, look to fall if you're within it, and if you don't, where you could possibly fall in within the breach clause and what the consequences are. And then you just have to do a balance between that. So it's an interpretation of the clauses. So again, when you're negotiating, make sure that the clauses are very clear and not long-winded, and again, make sure you've got a catch-all clause in there, because there will be events that you don't have. And if you don't follow the FM clause very strictly as it's required, then it's possible that you, as Lucinda said, you can't rely on the FM clause anymore, and you may be found in breach. So you're just going to have to get advice and balance that going forward. I don't know if Lucinda or Tiffany want to add anything.
Tiffany? Okay, thank you. Yeah, we have a few questions left and a few minutes left, so about 20 minutes left. There's a question by James, which I think it might be good if Tiffany can address that. So, to what extent do courts consider subjective commercial feasibility where it goes to the heart of the agreement, where defense of supervening impossibility is raised? So, in the case that you presented, Tiffany, where alternative mines exist to source, or would a South African court enforce specific performance, even where it may be to the absolute detriment of the party required to so perform, considering the position of the courts prioritizing public policy?
Thanks, Jackwell. Just listening to and looking at the question, it appears that to an extent, James is also referring to a potential hardship clause, because he's talking about the feasibility, whether or not the court will enforce it. But from my perspective, force majeure applies where the performance is impossible due to a particular event that's beyond your control. Whereas if I look at a hardship clause, it deals with cases where the agreed performance is still possible, but the agreement provides for instances where it's not feasible, like James is saying, commercially feasible to enforce this. Jack will also tell you about other hardship clauses that we've dealt with, where it just basically doesn't make commercial sense, or you're unable to do it. It's not viable for you to do it. You must draw a distinction. That's not an FM, that's a hardship, and your clause will specifically provide for instances in which you can rely on a hardship provision. But to me, that is not an FM event.
Yeah, as Stephanie has pointed out, so hardship is materially different, and in South African context, you have to. It's not a typical clause that you also find in the South African contracts. It's mostly, again, cross-border contracts. Some exceptional, we've dealt with some South African parties that have had hardship clauses, and hardship have been raised, and it is also a depending on the terms of the contract, whether you can raise hardship. Even if it's possible to perform, you might still be able to raise hardship in particular instances. But it's not something that you can just rely on because it's not part of our law. Hopefully, James, that answers your question. If you want us to maybe expand on it, we can definitely do that separately. Then there's a question from Pulani Koza. Could the Russia-Ukraine conflict and its impact on the supply chain still be regarded as force majeure event for contracts concluded after the inception of the conflict? Belinda, I see you shaking your head, and Lucindy.
Lucy, do you want to start or do you want me to?
No, you can go this one.
I think, again, it's down to foreseeability. You can foresee that there's an issue. So unless you've covered something specific in your agreement as to if and when the embargo on a specific port has been lifted, we will deliver. You know what you're getting into before you go into that, so you can foresee it. So again, just make sure your contract terms are very specific. It is foreseeable. So I don't think you'd be able to argue a supervening impossibility because it's not supervening. It exists already. And then just make sure that you cover your clause of your contract as to when things become deliverable and if they become deliverable on certain circumstances.
Anything?
No, I agree with that.
Okay. Thank you, Belinda. Hopefully that answers your question, Umlani. Then Martinez Boyson also has a question. What are the position of banks in terms of FM and their loan schedules where performance guarantees are in place, but a service provider manufacturer does not honor a performance guarantee or shows intention to perform and finalize its contractual obligations? Will the contracting party be liable in view of the non-performance of a supplier manufacturer? Lucindy, what's your view?
Yeah, that is, I think there's a couple of layers to answer that question. I think the first thing the way that I read the question is company A gives the performance guarantees to the bank. And so let's take it another way around. There's a specific loan schedule agreed to between company A and the bank because of performance guarantees given by company B that's going to render performance to company A. Again, it gets down to your force majeure and supervening impossibility of performance, whether it's objective or whether it's subjective. The mere fact that one of your suppliers are in default by not delivering for whatever reason, I don't think fall within a definition of force majeure or even supervening impossibility of performance. So I'm afraid if you are company A in that schedule and one of your counter-contracting parties does not perform, force majeure and supervening impossibility of performance is not going to help you. If factually you are unable to operate completely because of force majeure, there is a national lockdown, companies must shut down, then there, I think, is an argument to be made out that you could possibly rely on your force majeure vis-a-vis your banks. But otherwise, just because your counter-contracting party is not performing, even if that counterparty is performing as a result of force majeure, not sure it's going to protect you from your non-performance vis-a-vis the banks, unfortunately.
Thank you, Lucindy. You've dealt with that appropriately. So there's still a few questions, and we're getting to almost to the end of our program. So there's a question from Janisha. If one were to send out a FM notice, how long should you wait to withdraw the FM notice and advise the business capable of resuming? Is there a standard period? Tiffany? You're shaking your head.
Yeah. So there's no standard period. When you issue your force majeure notice, remember it will be applicable for as long as this event is there. If I use a simple example, if there's a strike and you cannot perform, but after 3 days the strike is over, you must withdraw your notice because now you are capable of performing. So there's no standard notice. It depends which event, which FM event you're relying on and how long this event is enduring for. So as soon as you're able to perform, you must withdraw. That can be 1 or 2 days, it can be a month, it depends. So there's no standard period of time. It is for as long as the FM event endures for.
Thank you, Tiffany. And in respect of, so it's when it's ultimately, as you say, dependent on whether you're capable of performing. So if you issue the FM notice today, and within a week's time, hopefully, again, taking into account the tips that Lucinda has given, that you've done all your analysis and assessments before you issue the FM notice, because you can't now, 2 weeks afterwards, saying there was an FM and now all of a sudden there's no FM. But there must be a clear impossibility that exists. And as you say, the contract will then dictate. Some contracts, maybe just to add, have a termination provision. So if the FM event endures for too long, the other party has the right to terminate the contract, taking into account the circumstances also. Then another question, in the event of a force majeure, does a third party verify the force majeure has occurred to avoid disputes between the parties? Belinda, what is your take on that?
So, I mean, the importance of your notice, make sure you set out your notice very clearly and it follows the lines of the FM clause. If it's undisputed, then the other party shouldn't dispute that there has been a force majeure. I think in the case study that we gave, the party rightfully disputed it because there was no intention to deliver before the force majeure event occurred. So I think if it's quite clear that it's there, it's unlikely that the other side will oppose the notice. If, however, the notice is defect in some sort of way, if it doesn't follow the procedure of the force majeure clause, or if they don't believe it falls within the force majeure clause, then they could dispute the notice. And they could say that your notice actually qualifies as a breach not to perform.
And that's why it becomes important to make sure again that before you issue your notice, that you actually objectively so have an FM event as contemplated by the contract, as opposed to what you think is an FM event.
Precisely.
Thanks, Belinda. Then a question from Charles Yu. On the all in beyond parties control in the FM clause, a few months ago, we encountered a number of breaches by overseas suppliers due to short supply of chips. Would you see this falls under the all-in clause? A shortage of supply was indeed a global issue, but it can also be attributed to supply not ordering the supply in time. Lucinda, and then any of the other panel members.
Yeah, I think, Charles, that falls again squarely within the case study. It seems to me that if there was a possibility that the non-supply was due to the supplier not ordering supply in time, if the supplier wants to rely on force majeure, it will probably be hit by the but-for test. And it also goes back to the question I answered earlier. One will have to look at the terms of your force majeure clause in your agreement to see how it has been constructed and whether a non-supply by your supplier can ever be regarded as force majeure. I think it would fall within the force majeure if your supplier sent you a force majeure notice saying, for whatever objective reason, I cannot supply you with chips because there's a worldwide shortage. then they will probably be excused from performing. But again, it will depend on the facts and whether they ever had the intention to perform.
Thank you, Lucinda. Then a question from Sibusiso. He asked the question initially on the FM clause, and he has a follow-up question. Is it acceptable to agree to a clause that provides that the parties are aware of COVID-19 and Ukraine war, and therefore the supplier won't be liable if there is a delay in delivery? COVID has been around for a while now and therefore foreseeable. Belinda and Tiffany.
I think if things are foreseeable and you could, it's the same as the ESCOM question. If you can make room for it, you should make room for it. You should make sure that your contract either defines when you need to perform. So if the embargo on X lifts, or if there's a lockdown in China, then we understand that performance might not be possible. So I think if you are making room for COVID, you need to be very specific about how you make it, because as you say, it's been around for a long time now, and it can't just be that the United States has, its numbers are skyrocketing. It's got to be a direct effect on the contract. So just because there's COVID doesn't mean that that is seen as a force majeure. It's got to, the event itself has got to be the direct reason why you cannot perform. And if you can foresee that, then there is an argument to say that you should have mitigated and made room for something. For example, with the supply question that was asked to Lucinda, if a year ago supply was suddenly short and you couldn't obtain the chips, that's fine. But it's a year later, and if you haven't made room for that shortage, so instead of ordering something 2 months before, you now have to order 6 months before. If you haven't made that adjustment, then I think it will be difficult to argue a force majeure or supervening impossibility, unless it's very specific that irrespective of what's happening, if there's a COVID event, it's got to be very specific and very wide for it to cover COVID in general or the Ukraine in general, I think.
Thank you, Belinda. Tiffany, do you have anything to add?
No, I agree. So I think, to put it simply, yes, it is acceptable to agree to certain things, but you'll have to be very specific. What about COVID-19 is foreseeable now that you're excluding? What in relation to the Ukraine war? I don't think it can be as simple as it's stated in the question. You have to be very specific as to which provisions, which events you are now excluding from the FM clause, and it will be dependent on the wording of the provision, which was also set out by Belinda and Lucinda. It's very important to set out exactly which events you are excluding from the FM event. It can't be as simple as COVID-19 and the Ukraine war, because there may be ancillary events that is unforeseeable, and either one of the parties should be then entitled to rely on that unforeseeable event. So your clause will have to be very specific.
Thank you, Tiffany. Then a question by Tandekule. What is the major difference between force majeure and supervening impossibility? Belinda, you've dealt with that, so easy answer.
So a force majeure is a specific clause that's included in your contract. Supervening impossibility is a common law principle applied in South Africa and other jurisdictions, where if you don't have a force majeure clause and something happens which is not foreseeable and is outside of your control, and there is no force majeure clause, then at a common law level you can apply for a supervening impossibility. A force majeure can be a supervening impossibility, but it's very specific and it's included in your contract. Supervening impossibility on its own, without a force majeure clause, exists at common law in a lot of jurisdictions. So one's contractually based is the short answer, and the other one is a common law remedy. I hope that answers the question.
Thank you, Belinda. Thank you. We are almost close to the end, about 5 minutes left. So I'm gonna ask last question, and then we can have final remarks from each of the panelists, and then the remaining questions we will then deal with afterwards and send you the responses directly. The last question, so maybe an easy one, is from Lerato. What is the maximum period of time that can be stated in your FM clause that the FM event must endure before enforcing the clause? So I'm going to hand it over to Lucinda, and then Lucinda, maybe after that, just your final remarks, and then Belinda and Tiffany, and we will then close the presentation.
Yeah, Lerato, there is no minimum or maximum period that must be stated in an FM clause. What you will find is in an agreement, it may say that in the event of force majeure, you must notify the other party within 24 hours or within 48 hours of the occurrence of the force majeure event if you want to rely on it. That is a contractually agreed and negotiated term of the agreement. And then, as Jackwell says, sometimes where time periods does come in is where especially in circumstances of a lease, for instance, or where time is of the essence in terms of performance of the agreement, what you will find is that the agreement will say where the force majeure event has endured for, let's say, more than 20 business days, then either party can cancel the agreement. So it is entirely up to the negotiating powers of the parties and what is ultimately agreed to, but there's no prescribed minimum or maximum period that must be stated in an FM clause. So I hope that answers the question, and maybe just some parting remarks. Again, I think there's that old saying that prevention is better than cure, and I think the answer here and the one takeaway from today is when you are planning to enter into a new business venture is to get the proper legal advice to ensure that you negotiate the best possible commercial terms for your business, not only in respect of force majeure, but also limitation of liability and then dispute resolution mechanisms. So Jackwell, that's the last bit from me, but thank you everybody for joining.
Thank you, Lucinda. Belinda?
Thank you, everyone, for joining, and to my colleagues for being such great support. I think I agree with Lucinda. The takeaway is just when you are negotiating your contracts, look very, very carefully at every single clause. Some people tend to brush over the dispute resolution clauses and the jurisdiction clauses and the law clauses because you don't foresee that the contract is necessarily going to go wrong. But like you would go into any commercial transaction on any other basis with any other clauses, look very carefully at those clauses and understand what they mean. Just because you assume that in South African law this principle is applied this way, don't assume that the English law or whatever other applicable laws under the agreement is going to apply it the exact same way and it will have the same consequences. So if you are going to contract into a jurisdiction and an area and a law that you are not familiar with, just make sure you understand what the consequences, or at least your attorney understands what the consequences of that are. They are very important clauses and people tend to only focus on them, unfortunately, when things go wrong, and by then it's a little bit too late.
Thank you, Belinda. Tiffany?
Thanks, Jackwell. I think I share the sentiments of Belinda and Lucinda. I think in a nutshell, the takeaway from this entire session, and I think to a large extent the answer to most of the questions that was posed to us, is you need to look at the provisions of your FM clause. I think more often than not, we don't think that it's going to happen, so we don't pay attention. But the extent of your protection, the period of your protection, and the events that you can rely on, all will be dependent on the wording of your contract. So I think the takeaway of today's session is you all must go and have a look at your FM provisions and send us your questions. But thank you everyone for joining, and thanks Belinda, Jackwell and Lucinda for today's session.
final word from me. Again, thank you to the panelists. It was very informative and insightful. I see all the comments from all the attendees. Also, they found the session very informative and useful, and we'll definitely have future events like these to have practical insights on various issues that affect your business. And the last takeaway, as all the panelists have said, is when you look at your contracts, as contracting part, carefully look at those, the precise terms of those agreements, make sure you understand that, and to mitigate your risk, don't wait for it to happen. And so if you negotiate the contract, usually the FM clauses, the breach clauses, the dispute clauses, the last thing you worry about is the you worry about the honeymoon, and you're busy negotiating a contract, and so once the contract is done, then there's a dispute 2-3 years down the line, then you worry about those clauses. So make sure you deal with that from the onset, as opposed to later on. Then you can mitigate all the risk, or at least most of the stuff that we've highlighted. So thank you again, and hope to see you soon. Bye-bye.